Mr. Stevens, FYI, I just dropped into the chat window the public link if you wanted to share that with your client. That would be a direct feed into the Zoom meeting.
Okay. Thank you.
Thank you, Jason. Mr. Stevens, will your client need to testify as well?
No.
Okay.
We're ready on our end, Your Honor, whenever the city is.
The city's ready.
All right, then let's go ahead and get started. It's a little after 1 o'clock. This is the matter that was noticed for 1 o'clock on today's code enforcement agenda. The case is CE 200-30246. The address is 717 Forest Hill Boulevard. And do we need to get anybody? Well, who do we need to get sworn in at this point? I have Mr. Posner on my screen.
Magistrate, I would recommend that anyone that speaks be sworn individually before their testimony, if that's okay with you.
No, that's yes. That's I'm just trying to figure out who that's going to be. So I only see you, Ms. Rothberg. I see Mr. Green and Mr. Posner. Is there anybody else? Mr. Stevens, are you going to be testifying as a witness? Or are you acting as counsel?
I'm going to be acting as counsel, and I mean, in an effort to streamline, I think we're going to be able to stipulate to the violations with some caveats. So I don't know if we're going to want to go through the whole thing, but I'll put that out there that I think we are going to be in a position to just again stipulate to the violations and just discuss thereafter.
Given that, Ms. Rothberg, how do you want to have a discussion about the stipulations between the attorneys and see what you can agree to?
I certainly am happy for Mr. Stevens to go ahead and list the violations that he wants to stipulate to as being violated. And then if we need testimony on any others, we'll do that.
That makes sense. Mr. Stevens, does that make sense from your side?
It does, Your Honor.
Why don't you go ahead and tell us what you are in a position to what you will stipulate to.
Okay, thank you. Just by way of background, Magistrate, it's been a little while. We were last before you on February 24th, 2020, related to a number of violations. Specifically, the allegations were that my clients were in part having weddings on their property and were having people stay there while they were active code enforcement violations and didn't obtain the proper business certificates and licenses in order to do all of that. What we're willing to, at the end of that hearing, what transpired was that Your Honor came to the conclusion that the violations existed and that they were given X amount of time to go ahead and obtain permits related to the violations. And Your Honor ordered that no further events be held on the property. And in the event that an event was held on the property, for each day an event was held, there would be a $1,000 per day fine. Your Honor's order was entered on, I believe
it's dated February 28th.
Right, February 28th. And our hearing was that earlier that week on that Monday on the 24th. And if, again, a lot has happened and it feels like a lifetime between then and now. But at the beginning of the hearing, I'd asked for a continuance because my client was out of the country. And Your Honor said that you would be willing to give me the continuance so long as we would stipulate that the wedding that everybody knew was scheduled to happen that weekend would not go forward. And I told Your Honor, I said that, you know, I'm not in a position to do that because we didn't want to ruin a woman's wedding 3 days before her wedding. And so the hearing went forward, notwithstanding my client not being there. And even though Your Honor was aware of everything that was to transpire that weekend, the order that was entered the day that the wedding was to take place did outline what the fine and the penalty would be in the event that my client made that business decision to allow the wedding to move forward. So to your question, what we're prepared to stipulate to today, just these violations are all arising out of the event that took place on the day of your order and the day after your order. And it is that wedding that was discussed at the February 24th, 2020 hearing before Your Honor. It did go forward as my client was not, did not want to ruin a woman's wedding 3 days before. It was to go forward. We are willing to stipulate to the violations as outlined in the citation, with the exception of the classification of each of these violations as being irreparable or irreversible. The city is asking for a $15,000 fine for these violations. I think from a legal perspective that the 2 days that we're talking about would not fall into irreparable or reversible as to what we're talking about. Moreover, Your Honor already considered this whole thing the last time around and outlined what the penalty would be in the event that a violation did occur. And we do concede that the violation did occur on those 2 days. Leading up to this hearing, several efforts were made to try and for us to not have this hearing, for us to just simply, my clients to just write a check for the $2,000 and be done with it, because that was what, again, Your Honor had ordered the last time around. The city was not interested and indicated that they were going to be pursuing this irreparable or irreversible order from Your Honor. And again, just lastly, I would just leave off with, notwithstanding the image that was painted of my clients at the last hearing, this isn't some large wealthy conglomerate or property management company. This is a husband and wife operation. This property was their primary source of income while they've been living overseas near a specialized school for their special needs child. They've had no income from this property since that February wedding. With the exception of the wedding that took place on February 28th and 29th, they've complied completely and respected Your Honor's order and worked diligently to get the property back up to code. Everything's been resolved on the property with the exception of there's one little disagreement on a multiplier on a permitting application that they're working out. But nevertheless, we come here to be held accountable for the violation. We understand that Your Honor said that if we did it, there would be $1,000 a day fine. I would ask Your Honor to consider that the financial circumstances of the world have changed a little bit since then because of the pandemic. If Your Honor was in any way inclined to have the fine be less than that, I would ask for your mercy in that request. But at the same time, to the extent that Your Honor is not inclined to, then the fine should be as you directed it last time, again, $1,000 per day. And we stand willing to comply.
Okay, so let me hear from the city.
I guess in order for me to go to state a position, I need to know, I heard that they had complied. Does that mean that the business tax receipt was pulled and a certificate of use was approved, or no? So
those two items cannot be done until the other violations were cleared up. All the other violations have been cleared up with the exception of one outstanding permit related to electrical work that was done. As basically as soon as that one thing is resolved related to a 4 times permit, they're able to go ahead and apply for all that stuff. But I could represent to the magistrate this afternoon that there will be nobody staying at the property. There will be no events at the property until that is done. It has not happened since that one February wedding that was already on the books the day that the magistrate entered his order. That is my client's representation to this tribunal that they will not be in violation of it.
Why don't I do this? So it appears to me there are this case that we're hearing today has 4 code sections that are listed as being in violation. So based on what I've heard, let me just take them one at a time and ask, make sure that I understand Mr. Stevens' position in terms of the stipulation. So the first is 2232A, certificate of use required. There are no certificates of use for this parcel pertaining to on-site business events and for the rental of the property. And then it lists the February 28th and 29th date events as irreparable and irreversible. Do I understand you are stipulating that there was no certificate of use, but you are not stipulating that the February 28th and 29th events are irreparable and irreversible?
Correct.
Okay. So the next section is 2635B. And that specifically lists repeat / irreparable violation. The violation of event on February 28th and 29th are irreparable, irreversible. You are not stipulating to that.
To the classification of it, correct.
The next section I have is 94-272B, permitted use table 9-1. The use of the lot for public and or private use of events, venues, etc. is not permitted per the Planning and Zoning Department. Cease and desist this illegal use of land, building, or structure. And then again, it lists the February 28th, 29th events and alleges those to be irreparable and irreversible. So you are stipulating that the use is not permitted, but you're not agreeing that the February events were irreparable and irreversible.
We're stipulating that he did not have the proper license and permits at the time, therefore it would not have been permitted. And yes, that we do disagree with the classification of it being irreparable and irreversible.
And then the last code section I have is 94-6, restrictions on land use. And again, it alleges that the February 28th and 29th event was irreparable or irreversible. And then it goes on to say that the use of the lot for public or private use is not permitted per Planning and Zoning Department. Cease and desist this illegal use of land, building, or structure. So again, you're stipulating that it is not that the use was not permitted, but you're not agreeing that it's irreparable and irreversible.
They were issued a tent permit for that day, but as it's written, yes, we are stipulating to the violation as it's written with the exception of the classification.
So it appears to me that the respondent is stipulating to the substance of the violations, except for the allegation of them being irreparable and irreversible, and therefore what the appropriate penalty would be. Let me hear from the city based on what the stipulations, what we just discussed.
Well, I think that one of the things that I heard the property owner's lawyer indicate was that it's $1,000 a day only if an additional event is held. Not how I read the order. I read the order to say if the owner respondent does not comply, they should pay a fine of $1,000 a day for any violation that continues to exist. And we also heard that no certificate of use, permit, or business tax receipt has been obtained. I think that it would be the city's position that it's $1,000 a day from the 28th through today, if those things haven't happened. So I just wanted to put that out there. I also would read for the record from the last hearing that, and this is may not be exactly verbatim, but as a quick type from the last meeting, quote from the special magistrate as accurately as I've transcribed it, could be a little off. It says, and quite frankly, we are talking about something that hasn't happened yet. You know, I think that any future event could arguably be considered a new violation that is irreparable and irreversible in nature, and the penalties that are associated with the irreparable and irreversible violation could be argued in that case. So I think that's what we're doing here today. At that time, you weren't judging the hypothetical case of what if something happened, but rather indicated that that should be brought forward at another date, and that's what we're here for today.
I guess the best way then to proceed at this point, it's your case to prosecute, so you've heard what the stipulations are, but I think you're entitled to put forward whatever testimony you feel you need to at this point to establish what has not been stipulated. And
Okay,
why don't you proceed?
if I may. Mr.
Oh,
Posner,
we still
please.
need to swear people in too, though. So I guess I can do that. Let me just do that as we go. So why don't you call your witness and then
The city would call Mitch Posner.
All right, and I can see you, Mr. Posner. You raise your right hand. Do you swear or affirm under penalties of perjury that your testimony will be the truth, the whole truth, and nothing but the truth?
Do.
Thank you, sir.
Please state your name for the record.
Mitch Posner,
What is your position, Mr. Posner?
Code Enforcement Supervisor for the City of West Palm Beach.
And what's part of your job function as code enforcement supervisor for the city of West Palm Beach?
Oversee magistrate hearings, lien reduction, supervise staff, monitor accuracy of our caseloads.
Sure. We're here today on case number, actually, violation at 717 Forest Hill Boulevard, correct?
That's my understanding.
Okay, and what what case number do you have for that matter?
For today's case, I have case CE 20030246.
Thank you. And have you had an opportunity to review the code file in this matter?
Yes, ma'am.
And on your review, have you found whether or not there continues to be a violation of 18-162A?
For today's case?
Yes, for today's case.
Hang on, I'm not sure I understand the question then.
Why don't you tell me what violations are being prosecuted for this case at 717 Forest Hill Boulevard?
Okay, what we cited for was 2232A, 2635B, 94272B, and 946, and all as irreparable, not as a continuing thing for those 2 days that occurred on February 28th and 29th.
Okay, and what is irreparable in your view as a code enforcement officer for the city of West Palm Beach?
Harm that cannot be fixed.
What type of harm?
Well, in this case, the original case was adjudicated as these events being so severe, there was an immediate cease and desist. And there were 2 more days where the disturbance of the neighborhood was again that severe, and they can't take that back. They can't undo the disturbance to the neighborhoods on those evenings. That is absolutely fits the definition of irreparable.
Do you have any evidence as to whether or not the property is still being held out for rent as a wedding venue?
Only the online advertisements that are still accessible to the public saying contact us as a wedding venue.
Is there any other evidence that you'd like the special magistrate to consider in deciding whether or not this property at 717 should be deemed a repeat irreparable, irreversible violation?
We do have pictures from the 28th, 29th that there were events, and I can show those, but that doesn't seem to be disputed as to whether or not there actually was an event those dates.
We'll go ahead and show them anyway for the record. The lawyer doesn't have provide testimony, but rather just argument.
Is it on there?
You're sharing your screen, yes, but the photographs are not showing yet.
Okay.
Maybe double click.
Mitch, you have to click on the file.
I think I had the wrong file up. Okay, let's try this again. Is it there now?
Yes.
So I just have to go through them one at a time on this thing?
Yeah, describe what we're seeing.
All right. Apologies, magistrate.
No worries.
Okay, just gonna have to do it one at a time. I can't do the usual slideshow option. Is the first picture up?
No, share your screen again. Okay, the first picture is up. If you'll describe what we're looking at.
Okay, it's from across the street. Basically, you can just see the top of the tent. That's the white in the background there. We were setting up the tent for the event.
Okay,
Okay, sorry for the,
and what was the date of that?
that was on the 28th. And this next one is also the 28th. It's a closer picture of the tent. Certainly hard to miss from that angle.
Okay,
Okay, now the rest of the pictures will be from the 29th. Okay, that's the 29th. See if I can go through these quickly somehow. Nope. That's more of the same, just different angles of the tent and some of the people there. Lost the share function. There it is. Okay, this is the traffic along the residential street there. It's not Forest Boulevard. It's a side street around the corner from it. So all the residents had parking up and down the entire street from the valet's parking over there. More of the traffic, you can see the valets sitting there on the grass with their valet sign and the sign telling them where to stop to get valeted. This is on the side street in front of a residence as well. Closer picture of the same thing. Another angle of the tent, some of the people at the event.
I'm not seeing that photograph.
Oh, sorry.
There we
Is
go.
that better? Okay,
Thank you.
you're welcome. Okay. Hard to misunderstand the intent of that sign for the valet parking for the event. Again, residential neighborhood. This is more of the tent setup. This is from earlier in that day on the 29th. Okay. Now we have them parking on the swale area, the city right of way there. More of the event setup. Again, that's from the morning. Valet people parked on the right of way right next to their valet sign. That's simply for frame of reference for 717 Forest Hill. That's the address on the front gate. More of the tent set up that morning. Again, the 29th.
I didn't see that one.
This one, sir?
Thank you.
You're welcome. That's the same gate. You can't see the 717 from that angle, but it's a further shot. As they're set up, they brought in an ice machine for their event. Again, all on the morning of the 29th. Another angle of the valet sign out front. This is the last picture. This is where somewhere they were setting up for the food area. Again, apologies it took so long. That's all I've got for pictures. Didn't have any other evidence to present for this case.
I do have one question. Has the Code Enforcement Department received complaints from the neighbors specifically as to the use and operation of this particular property?
It would take some time to count how many we received prior to the previous hearing on this property. For this one, we have not received any since the 28th and 29th. We did receive them that weekend and that Monday morning.
When you say that weekend and that Monday morning, are you meaning the 28th and 29th?
We received, when we came in Monday, there were many complaints waiting for us from the 28th and 29th and the events that transpired those days.
What were the nature of the complaints?
Unchanged from the previous issues, the disturbance of noise, the disturbance of the traffic, the late hour of the event on the 29th, and simply how much it was affecting their daily life in their neighborhood.
Okay. I don't have any other questions of the witness magistrate.
Thank you. Mr. Stevens, do you have any questions for Mr. Posner?
Just a couple, Your Honor. Mr. Posner, you testified a few minutes ago that my client is still advertising this property for wedding venues. Do you recall that?
Yes, I do. That was relevant to the previous case.
Right, but since the magistrate made his ruling back in February, have you seen any advertisements, or as we see here today, are you aware of any advertisements that my clients are currently using to advertise the property at issue as a wedding space?
Yes.
Okay, can you please direct us to a website and we'll go ahead and check this out?
I can email you the links if that's helpful. I don't know how to do it in a Zoom hearing.
Okay. Well, if you want to, you know, drop it into the chat. You can copy and paste it in there.
It's going to take a minute because I have it on a different computer.
Okay.
And while we wait, Magistrate, I would like to move all of the photographs that were viewed into evidence.
Mr. Stevens, do you have any objection?
I do not.
That's granted. Those will be made part of the record. Without objection.
If everyone would check their systems to make sure they're on mute, I would appreciate it.
Okay, I just added the first one. I just added the second link.
I'm on mute. Here we go. These are both links that you identified for the last hearing, right? Now you're muted.
Can you repeat that?
Yes. So both of these links that you just sent us, these were both links that you had identified and located for that hearing we had in February. Is that right?
Yes.
I think I remember you putting, or somebody from the city putting these up, right?
I'll take your word on that. I'd have to review to recall that.
Okay. Let's start with the second link first, which appears to be
Let me stop you real quick because I can't see anything that the two of you are looking at.
Okay. Magistrate, if you click on the chat function on the bottom of the Zoom, are you operating on an iPad or a computer?
iPad.
Okay. You know what? I can share my screen and you can see the website, so that way you don't have to finagle around, if that would make it easier.
Oh no. Okay. So here's the. All right. So I can now. Let's see. Can you still hear me?
Yes.
All right, because my video. I don't. Can you still see me?
You're blacked out with just your name.
Yeah, because I can now see RHH event inquiry form
Yes.
is what I'm looking at.
Right.
Is that what you're looking at as well?
Yes, that's the second one we're going to take first. I'm going to ask Mr. Posner about.
Okay.
Okay. Mr. Posner, again, we're looking at the Google Doc website that you put in here. Are you familiar with any external advertisement that actually links the website that you found prior to the last hearing currently to let people get access to this form?
Before I answer, if I can ask Magistrate, how does this relate to today's hearing for a irreparable violation?
Well, I'm quite honest. I'm going to have a lot of questions about that. I don't know yet, so I'm kind of.
All right, and I'm happy to provide the tribunal with a little clarification, if I may.
Go ahead.
Okay. One of the elements that Magistrate, that you're required to consider under the rules is the gravity of the situation, and any other element related to proving up this irreparable or irreversible. We're coming to the court conceding to the point and trying to show that we've done good with the exception of this one day that, again, we didn't want to ruin this woman's wedding on the same day that the order came down. The forms that we're looking at are not readily accessible to the world unless you already had the link that existed prior to this last hearing. And what it appears, because it's really not relevant to the violations, but they brought it up. And so I'm simply just discussing the fact that these links, while they do have the links for them, they're not publicly available anywhere because my clients have taken efforts to not hold themselves out as a wedding venue since Your Honor made it your last ruling.
Okay. So I couldn't go out there and find these pages we're looking at is what you're suggesting.
And I can show you on the second one, the one we're going to look at next, but on this one, this is just a Google Doc link. And so anybody that has this link can access the page that we're all looking at right now. And so my question to Mr. Posner was, are you aware of any publicly available website that links the world to this website?
And Special Magistrate, before he answers, if I may, I would also like to know if Mr. Stevens is going to testify about websites and stuff, that he then be a witness and be sworn.
They opened the box with his testimony, Magistrate, telling us that they're still advertising this property for weddings.
So why don't you ask your questions and let's see what answers you get.
Okay, thank you. Mr. Posner, we're still looking at the Google Doc website. And my question to you is, I understand that you have this hyperlink. Are you aware of any publicly accessible website that links the public to the website you just provided to this tribunal?
Okay, that website is found from the first URL I sent, the other URL, which can be found on a Google search.
Okay, is that the only one?
That I'm aware of. I have not done an extensive search to determine if I can find it somewhere else.
Okay, let's go then to the first one that took you to this page. And again, that's a hyperlink that you identified prior to the last hearing, correct?
I believe so, yes.
Okay. Okay, so I'm clicking on that one now. Magistrate, you have that one to go to now.
And now we're looking at, there's a little diamond shaped logo in the upper left corner.
Yes. Yep.
That's what
Okay.
I see.
All right. So we're all looking at the same page. This is a sub page of the main page of this lana-katseros.squarespace.com. Does that look to be right, Mr. Posner?
Yes.
Okay. And again, you have this actual link because it's something you found prior to the last hearing, correct?
Yes.
All right. Now, if we actually go to the main page, we remove the word weddings from the hyperlink on the top, and we go to the main page.
That web address being?
The same thing that you gave us, which is lana-katseros.squarespace/ but no weddings at the end of it.
Okay.
Okay. All right. So that's the main landing spot for this website now. And this is, again, you just accessed it. So this is what's being held out to the public right now, correct?
Yeah, that's what's out for the public. I'm looking at a page that says events at the richhippieshouse.com and has, I don't know, roughly 15, 16 pictures of the Forest Hill property with a wedding event.
Okay. So again, I understand that, originally back before the last hearing, that there may have been a link on this main page that took you to that wedding subpage. Is there any way you can navigate to that wedding subpage from what is currently being held out to the public presently from this main page today?
I have no idea.
In fact, if you scroll all the way down to the bottom of the page, you see where it says holiday house plus vacation rental?
Yes, I do.
Do you see any reference on this page that today my clients are holding out this home for a place to hold weddings?
I don't see anything that says, oh, to hold weddings? No, it doesn't say weddings right there. It just has a lot of pictures of weddings.
Okay. All right. You also mentioned earlier, moving away from the websites, that you said you received complaints into the evening, that there were issues into the evening on February 29th, 2020. Is that right?
That was what I said, yeah.
Okay. Do you have any reason to believe that this wedding actually did not end at 3 p.m. on February 29th, 2020?
Just from the complaints that there was noise late into that day.
Past 3 p.m.?
I believe so. I
Okay.
don't have all the emails in front of me.
You showed us a number of photos. Do you have any photos of a party ongoing on February 29th after 3 p.m. on the property?
I'm looking. No, all our pictures were setting up in the morning.
Okay. Are you aware about a party that took place across the street from that house that day?
No, I'm not aware. I didn't receive any complaints from that property.
Were the complaints general in nature, or were they specific to the address of my client's property?
I only received complaints specific to 717 Forest Hill.
Okay. Okay. I don't have any further questions for you, Mr. Posner. Thank you.
All right, does the city have any additional witnesses?
I do not.
Okay. I guess then I would like to hear argument from both sides. Specifically, sorry, that was my iPad. Specifically on the issue of why these violations that have been stipulated to, why the events of the 28th and 29th do not fall under my February 28th, 2020 order, and conversely, why they are, or Mr. Stevens' position, are not separate, irreparable, and irreversible violations. It doesn't matter to me who goes first. I'm not that formal. I'll go ahead and let the city go first. It's your case.
Sure, I'm happy to go first. As I stated originally, when the magistrate heard this case back in February, the case was based on complaints that came in for events that occurred before the February 28th order. Those events were held, causing substantial impacts to the neighbors, causing neighborhood complaints because their residential neighborhood was being converted into a commercial event space for a wedding venue in particular. At that time, the owners of the property were told that they were required to do a number of things, including some construction for some illegal conversion of the buildings, and that was cited in the other order, that they were required in order to operate a rental to have the appropriate business tax receipt and licensing. And in addition, that they were required, if they were going to hold events, to have the appropriate permits for structures such as tents that required permitting. Knowing that they had an event scheduled going forward, they just assumed that the magistrate's order was $1,000 and that was a cost of business they were willing to accept to go ahead and continue to hold events in violation of the city's codes and ordinances. The impacts were shown clearly by some of the photographs, the additional traffic, the valet parking in a residential street, the complaints that the city received as to noise, whether it was during the day and or continued into the morning hours. Those are quality of life issues that the residents of that neighborhood has to deal with. Those quality of life issues are irreparable and irreversible. They had to deal with it. They had to suffer through them. But for COVID, they may still be suffering through them. Thankfully, the governor's disallowed, at least in this area, until the county allows vacation rentals to operate. They can't operate. Otherwise, we would be facing an argument that we can continue to have weddings so long as I pay $1,000 fee for each one. That's just not how we read the order. That wasn't the intent. If it is the intent, which, I mean, it can't be at $1,000 per event when they're required to have not only the permit for the structures, that might make sense that it's only for the structures, but they're required to have the business tax receipt to offer the place for rent, whether it be for wedding or otherwise. And they still, based on the stipulations, don't have any of the required business tax receipt, the certificate of use, or other things that are necessary to operate business at that location. The city respectfully requests that the magistrate, at a minimum, find that it's a repeat violation warranting a higher fine, which is $5,000 by the statute. And as put in the notice, you could find it irreparable and irreversible and impose a fine of up to $15,000 based on the nature of the impacts to the neighborhood. And with that, I would turn it over to Mr. Stevens.
Okay, I'm just, all right, thank you, ma'am. Mr. Stevens, go ahead and let me hear from you on those positions, please.
Thank you, Magistrate. Yeah, council referred to it as us just assuming that it would be a $1,000 a day fine. Magistrate, we took your order at its face value the day that you entered it, knowing that there was a wedding that day. This was, we can call it a business decision. We can call it a moral decision. There was a woman having her wedding there that day, and they knew that the potential consequences of that were, based on the order, $1,000 for each day that they allowed that wedding to go forward. And they, on their own, decided to accept that as the consequences of that. We're not trying to dance. We're not trying to mince words about it. The order says what it says, and it says that there'll be $1,000 per day for each day of any violation related to operating or holding an event or any type of short-term rental there. And my clients should be able to rely on what's in that order for the decisions that they make, because if counsel for the city is right and that they interpret it not as it's written, in that not only will it be $1,000 per day there, but if they don't get a business tax receipt or a business use, even on the days they're not operating a business there, because that's the thing. After that second day of that wedding, nothing has gone on there except efforts to resolve all those outstanding violations with the city. And they've done that. They've been working diligently with the city to get all those other violations wrapped up so they can apply for these tax receipts and these business licenses. But the idea that because even though they're not running a business there every day, they should be fined $1,000 per day is, I think, completely against what the intent was of your order and what was discussed at the last hearing. And to your first question, Magistrate, of how does this not fall under your initial order? Your Honor, it does. We were completely candid about everything last time. Again, with the continuance that we requested, that was ultimately, we didn't accept the terms of it because we had a wedding there that week. And we didn't want to cancel it on the same day that Your Honor entered it. This does fall within it. And the consequences are, as you've outlined them, and we are willing to accept those consequences and pay the fine as you've outlined it. They're not operating a business there. They haven't been operating a business there since this happened. They're doing everything right to get everybody on the same page now. The only evidence that they have put forth for you to consider on this irreparable argument is that there was allegedly some noise that you can't undo the noise. You can't undo some cars parked on the street. They haven't put forth any other evidence to support that. And look, if we were in circuit court right now asking for like a temporary injunction and we were talking about irreparable harm and all that stuff. That burden is super high. And I really, really can't imagine that. And again, I'm not making excuses for what's happened. Again, this was just a bad situation that we tried to make the best of. I cannot imagine that some noise and some traffic on the street would rise to the level of irreparable and irreversible harm that the city wants to create precedent on, that would then allow them to penalize their residents for something like this occurring. So again, I'm falling on my sword here. Your order says what it said, Your Honor. We fully accept that. I again can tell you that moving forward, there's not going to be any further issues, that everything will be done above board with this property. And my point with the website was, Your Honor, there is no representation being made to the public that this place is available as a wedding venue right now. It's simply not the case. The links that were provided were accessible. There's still live links, but they're not links that people can find on their own unless they had them before the last hearing. So we're doing what we can on our side. I'll stop talking now, but we'd ask that, Your Honor.
Actually, I have it here. Here's what I'm struggling with, and you touched on it. You know, in my view, this type of a violation where there's some event that has occurred, that in my view, that is the type of thing that typically is irreparable and irreversible, because once the event ends, I can't direct you to do something to cure it. It's already done. The question that I'm struggling with is, the city has brought a new case. This is a new case number so is it your position that these violations are more appropriately captured under the previous case as a disregarding of the February order, and should not have been brought as a new case at all? And I'll let the city address that as well after you've addressed that, because that's what I'm struggling with right now. Is this a violation of the first order, or is this a brand new case with new violations that do not fall under the first order?
Magistrate, I would take the position all day that this is a violation of the order. This was all put before Your Honor at the last hearing. The wedding that was to take place that weekend, the violations that were already in place, and it was discussed at length that, you know, obviously this was going to be happening, and you put in there specifically for any events that were going to be held at this property in violation of that code section, that the penalty was $1,000 per day. You already made that determination, and my clients relied upon that determination in making a decision for that weekend. If we now take the approach now that, well, you put that in there, but really it didn't mean anything, and they can just bring a new violation, cite him for a new violation, and seek these extraordinary remedies for irrevocable damages and whatnot, it kind of goes, it's as if there was no meaning to that second paragraph in your order, and it puts us in a bad position where we weren't able to make an informed decision on how to protect ourselves from what needed to transpire.
Okay, thank you. Response?
Sure. I'm going to go back to the order because I think it's important to see what specifically it says.
Okay. And I have it pulled up here.
Yeah, it enumerates in this particular paragraph all of the code sections that were violated. So it says owner respondent shall comply with code sections 18162A, 2232A, 82144, 94272B, and 946 by immediately ceasing and desisting operating property, including but not limited to engaging in short-term rentals and holding events at the property in violation of those code sections. That's the end of it. It's just saying you have to stop doing this. Fine. The next sentence is the sentence that is outside, that tells what the fine is. And it says, if the owner or respondent does not comply, the owner or respondent shall pay a fine of $1,000 per day for each day any of the violations continue to exist. So the violation of having a business at that property without the business tax receipt, without the certificate of use, and without the business tax receipt continues to exist for each day since the date of the order, that's not come into compliance. The second section is specific to an event, the 94.6, the structures without a permit and holding events themselves. I think it's two things. This case today before us are two things. One, it's a repeat offense of continuing to operate a business after your order, the 28th and 29th, of the certificate of use and the business tax receipt, if that's cited too, and I have to look because they don't cite all of the same sections as was cited in the original order. And it's also by virtue of holding the event without the appropriate special events permit, which is a separate thing, irreparable and irreversible as to that event. So it's both.
So the city's position is not only does it fall under the first order, but it also justifies the new case number with the new case and the new penalties.
Yes.
Okay.
Magistrate.
All right. Mr. Stevens, do you have any final arguments?
Other than what we've already gone over, Your Honor, no, I don't. We understand the nature of the situation. We made our decision based on what was in this order, and they're prepared to live with it. But at the same time, I'm going by what was in the order that was entered the last time we were before you.
All right. Well, in terms of, this is what I'd like to do. I mean, clearly we have proper notice. We have stipulations on the violations. As I did with the first case, I would like to give this irreparable and irreversible issue a little bit more thought, and then prepare a draft order that I'll send to both attorneys, and then we'll publicly publish it appropriately rather than shoot from the hip right now. I will make every effort to get that done within a week, so that this is not sitting around any longer. So I will commit to getting a draft order to both attorneys no later than a week from today, and then we will. I guess we'll have to proceed by having this on the next agenda that I sit at in order to publish it publicly. Okay.
Okay.
Anything else?
Thank you.
Anything else? All right, then it is 2 o'clock, and we will stand adjourned.
Thank you.
Thank you, Magistrate.
Thank you.